Okay, I can see a decent enough number now to get started, so I'll kick things off. Hi everyone, very welcome along to this webinar, Commercial Insurance, Basics, Pitfalls and Top Tips from CES legal patron Selig. I'm delighted to be joined by Kirsten Magee and Rebecca Logan for this one. So Kirsten's an experienced commercial litigator with a background in advising both private and public sector clients on a wide range of complex high value cases with particular interest in insurance also. And Rebecca is a senior associate in Selig litigation department and has a wide range of experience in contentious matters for commercial clients. So just to say there's time at the end for questions. So please do use the Q&A function. And with that, I'll hand over to yourselves. Kirsten and Rebecca, thank you.
Thanks, Vincent. Good morning, everyone. As Vincent said, my name's Kirsten. I head up the insurance litigation team at Selig, and Rebecca is my right-hand woman, as they say. So it's an area which generates a lot of case law, and we'll try to keep the law lecturing to a minimum as far as possible, and try and focus on what practically you can do to make life a little bit easier when it comes to tackling insurance. Now, Rebecca's going to kick off by taking you through some examples of the types of cover that you're likely to require. And obviously, as the world develops and moves on, then the types of insurance cover you might need also multiply. So she's also going to take you through the sort of key piece of legislation. So we're breaking our own rule quite quickly. We'll keep that to a minimum in terms of the Insurance Act. And then Rebecca's also going to spend a bit of time just discussing the role of the broker. Spoiler alert, the broker is crucial in all of this, and you should, if you haven't done so already, try to make sure that you develop a good relationship with your broker, because that can be crucial in terms of ensuring that you are adequately protected. And then finally for Rebecca, she's going to look at your obligations and what it is that you're required to do to keep yourself right in terms of your cover. And then I'm going to move on to look at things from the point at which a potential claim arises. So the issue of notification, which is a tricky enough one. Reasons for refusal. So, looking at the common reasons why claims are not paid out and what we can do to try and avoid getting into that situation. Your options if a dispute with the insured arises, so what the different channels are that we can use to try and address that. And then finally, we're going to wrap up with some key takeaway points. So without further ado, I will hand you over to Rebecca. Kick us off. Thanks, Rebecca.
Okay, thanks, Kirsten. Hi, everyone. Thanks for joining today's webinar. I'm going to cover, as Kirsten mentioned, just very briefly, the types of cover that will be relevant to your business or most businesses, a lot of which you'll be already familiar with, but just a quick overview, some of the key ones to just be aware of and to be familiar with. Of course, business interruption insurance, which is extremely relevant these days, post-pandemic. This particularly covers you for financial losses that flow from an unexpected event that disrupts your business, for example, a pandemic. Of course, professional indemnity insurance, which would cover you for any claims brought against you for the provision of professional services, so negligence claims, for example. Of course, employers' liability, which all employers must have by law anyway, if you have employees, which essentially cover you for claims brought by employees for personal injury, for example. You've also got public liability insurance, covers you for third-party claims brought against you, brought against the company, usually again for like the personal injury cases. And there's also cover for directors and officers, or people in senior management roles, where they might face claims directly against them for personal wrongdoing, for the likes of, or for personal liability. This, like, for example, breach of duty or mismanagement. So that might also cover them. More particular or specific cover that's available as well, that would be more specific to your business, the likes of product liability, cover for defective products, cyber, increasingly more important these days, which would cover any risk of cyber attack or cyber crime that may shut down your business for a period of time. Can be very important to have these days. Land and buildings, of course, protection of your physical assets, contents insurance, all the rest of it, very familiar cover. Environmental, again, another one that's increasingly more important these days, provides cover for environmental risks. So, it helps to restore damage caused by environmental accidents, pollution events, etc. And one that most people here will be extremely familiar with is constructional risks, to cover basically all risks involved in the construction project. And a lot of these can be tailored to include all elements of others, to give you that sort of all-encompassing cover that you need for your business. So policies can be written on two bases, either a claims made or a claims occurring policy. And it's important to really understand which is which. And it's sort of, what it says in the tin exactly. A claims made policy is, it should pay out for when claims are made during that policy period. So it's not actually when the incident or the breach occurred, which could be a number of years previous. So a good example of this would be your professional indemnity cover. If you're faced with a claim for negligence that the incident may have occurred years previous, but you've only been notified of the claim now, the policy that should respond is that policy that you have in place at the moment. So usually that 12-month period. That differs from a claims occurring policy, which would pay out for claims that arise when the loss or damage occurred. So not and what policy was in place at that point in time. So a good example would be if you had, for example, a claim brought by a former employee for an industrial disease such as asbestos or something like that, where the damage may have occurred years previously, sometimes decades before. It's actually the policy that was in place at that time rather than the current policy. But it is just important to be aware and to make sure you have sufficient cover in place no matter when that insured event takes place. So something, again, for a broker to be to assist you on at the outset, just to make sure that you have the appropriate cover at any given time and there's no crossover. I'm going to touch on a few of the key terms that insurance policies contain. Now, as we know, insurance documents are extremely long and boring, and I'm not going to go through every term, but just some key ones that if you in the business are particularly it's within your responsibilities within the business to procure insurance. These are just the things to be aware of and to know sort of inside out in relation to the cover that you have. So an obvious one, of course, is the defined insured risk. So does that sufficiently cover what you need it to? And how is that defined? And just to make sure that there are no exclusions in there that you didn't anticipate. So so just to make sure that you've got everything covered that you need to. Other key provisions are the warranties section of the policy. Now, this is basically the statements that you've given to your insurer, representations of fact that, if found to be untrue, would potentially invalidate your policy. So it's just to make sure that, again, those warranties that you've given are true and accurate. And because if there is a breach connected to any actual loss that has occurred, then your insurer may be entitled to reject any cover. So a good example of that might be, you warrant that you check your fire alarms once a month or on a particular date. A fire then occurs, but you haven't been checking, then you may not well be covered. But it may be that you've not checked on a particular date, but you did eventually check, and a fire occurs. Well, that might not then be enough for that insurer to reject your claim. It has to be connected to the actual loss that has occurred. So something I think we'll touch on a bit later when we talk about disputes arising with insurers. But again, just key your warranties to make sure that they're all true and accurate. Notification requirements, so be across this aware of the provisions that are required of you. So if a claim is to arise, how must you notify your insurer? Who must you notify? Because you may have multiple policies, multiple insurers, and you know, different types of cover, like the claims occurring or claims made policies. So just who do you be aware of who you must notify, how must you notify them, and there'll be particular requirements in there and when. So it may say that you must notify them immediately or as soon as possible. You know, what sort of timescales are there, and are you notifying them of the actual claim, or could it actually say something about, you know, you normally see wording like the occurrence of an event likely to give rise to a claim. So just be familiar with what those requirements are, because again, as Kirsten will explain later, getting that wrong can have a serious impact and have a serious knock-on effect. Aggregation clauses, they're quite important to get your head around, quite complicated, but important. They can work both ways. There's pros and cons here, but it essentially is when you've got lots of smaller claims that could be grouped together to form one claim under the policy rather than lots of individual claims, but they must have some sort of common feature, unifying factor that brings them all together. And this is quite relevant when it comes to your policy excess. So you know, do the small claims, do they fall under that excess, or they or when they all add up together, what is the limit of the liability of the insurer? So, you know, for example, if we're talking construction, you might have a small design defect that, you know, you apply across all, you know, lots of different projects, and there are multiple claims start arising. But say, you know, for small sums less than your excess, say your excess of 50 grand, then you may be able to rely on an aggregation clause that groups them all together into one claim that brings you over that excess, and say they all add up to £2 million. It would be extremely beneficial to be able to rely on that. On the other hand, though, if there's a limit of the employer's liability that only covers you to 2 million, but the value of the claims all added together are 10 million, then that's obviously not sufficient for your needs. So again, do the aggregation clause, do they provide what you need them to? And again, policy excess, just something to be aware of and familiar with. Now, as Kirsten mentioned, we're going to just run through what the role of the broker is in all of this, and I'm sure a lot of you would be familiar with using a broker anyway and have relationships there. But they're very useful, and you should make use of them where you can, as they have the appropriate expertise. Their main job, of course, is just to find you the appropriate cover that your business needs, and they have various duties to you. So, you know, you need to first of all confirm, are they independent, and, you know, who do they act for? Are they just an agent of the insurer? But most of them will be acting as your agent as such, so they will have duties to you. And again, if they have fall foul of those duties, then there could potentially be a liability there to you if, for example, you don't have sufficient cover. So important to know that. Make sure that they're authorised, regulated by the Financial Conduct Authority, all the usual stuff. How do they get paid? Things like that, practical things to be aware of before you sort of enter into that relationship. But essentially, they have various duties to you, as set out on the slides there. They must always act in good faith. They may have contractual obligations, and they have the obligation to act with reasonable care and skill. So, as in not be negligent. And if they're in breach, again, you know, you may find yourself underinsured as a result of any failures that they might have. Then you know, you may have a claim against them if your policy doesn't respond. Now, they in their actual role to you, they should be able to advise you of what your duties are and elicit the information that's relevant to the claim from you. And they should then also advise you the consequences of failing to do that. So they'll need to make various inquiries of you to, you know, elicit the information that ought to be disclosed, and they're held to a certain standard. But there's no general rule, there's no specific questions that they must ask, but it's really just a case-by-case basis, and they're held to a particular standard, you know, of a normally competent, prudent broker. So very, very useful when they do a good job. But of course, you have obligations as well, and this comes with whether you've got a broker or not, and applies at placement and at renewal. So these are key things for you to be aware as a business, and this has all been set out now in the Insurance Act 2015, where it creates this new duty to provide a fair presentation of the risk. And this is essentially where you have a duty to disclose all material information relating to that risk that you're insuring. So that essentially means anything that would influence a reasonable underwriter, insurer, in deciding whether to write that risk, and if so, on what terms, and of course what premium to apply. What's material is, you know, it depends on the case, but you have an obligation to not make misrepresentations. So as I mentioned earlier, you have to disclose everything and make sure that everything you're saying is true and accurate, but also that you provide as much information as you possibly can that's at all relevant to the risk. And it covers any knowledge that you have as a business, and that is knowledge that you have or ought to have. So something to be aware of, and it's very important that whoever is in charge of procuring your insurance is aware of any key information. It's fed up, you know, through and you have systems in place so that information is fed to the correct people or a senior management team who have that knowledge, because it's not just what that person's knowledge is, it's what it ought to be. So there's just summarize really that you have that obligation to disclose material circumstances that you knew or ought to know. And a good example of this, or, you know, a cautionary tale really, is this case of Young against Royal and Sun Alliance PLC. Really the first case to deal with this new duty from the Insurance Act of providing a fair presentation of the risk. This is a case where there was it's a Scottish case where there was a fire at Glasgow nightclub, and of course the owner sought to claim under his insurance, but the insurer rejected his claim on the basis that he didn't provide a fair presentation of the risk, and he didn't provide full disclosure. It subsequently found that he had been a director, previous director of 4 other businesses that had either been dissolved or were found to be insolvent, but that wasn't disclosed at the time of the placement of the insurance, and the insurer rejected the claim on that basis. You might think, is that material to the risk of fire? But the court disagreed, and it found that this would have featured in as all material information relating to the risk. So it really centered around that requirement for him to disclose sufficient information to provide the insurer with a fair presentation of the risk. You must disclose every circumstance that would influence the judgment of a prudent insurer. And it was also found that this particular insurance policy was conditional upon there being no insolvency or bankruptcy events in the past. So again, that insurer was entitled then to fully reject the claim, and there was absolutely no cover whatsoever. So just a cautionary tale that it's very important to disclose all material information. Again, your broker will come into this and advise you of these obligations, but it always really comes down to you as to what information you provide, and that is key. And Kirsten will explain sort of what can happen in those circumstances when you do get into disagreement with the insurer on these points. So yes, I'll hand over to Kirsten for the rest of the webinar.
Thanks, Rebecca. So Rebecca's already touched on the issue of notification. Just briefly to recap, that is one of the things that can go wrong. So I just wanted to take a bit of time to talk about it. So again, yes, you need to think about who you need to notify. This is an example of when you should speak to your broker in the first instance, because they can keep you right. Most sophisticated companies will have a whole portfolio of cover, so you know that something's gone wrong and that you may need to make a claim, but the broker can help you sort of navigate which policy is most likely to respond, and identify the relevant insurer. Rebecca touched on the claims made versus claims occurring point. So yes, that's also where that comes to the fore, where you have to work out whether you're looking at the current year's insurance or whether it's something you're going to have to hark back to previous years. So look, the other point is around when circumstances arose. So it's sort of keeping on top of whether those things develop into a claim and keeping good records of what's happened in the interim. When to notify a claim, policy terms vary on everything you'll find in insurance, but including when to notify. So some policies will be pretty draconian and the notification has to be made immediately. Some will say as soon as possible or as soon as practicable, and that obviously leaves a lot of scope for debate as to when that ought to have been made. And then others have got a sort of clear time frame within 14 days, within 30 days of the incident. So again, important to be across that, just to have that in your mind when you think you might need to revert to your insurer. And then, what to notify, what is it that you're actually notifying? Claim against the company, if you're talking about sort of professional indemnity scenario, if you've given design advice, for example, in the context of a construction project, be pretty obvious when a claim comes in, if you're, because you just receive proceedings, that's pretty clear. Again, if you're talking about material damage, if there's if your office burns down, you'll know that you've suffered some sort of event that you need to look to. The circumstances, if you're required to notify a circumstance that is likely to give rise to a claim, that can be a little bit more difficult to judge. There is a bit of a judgment call required, and often policyholders are hesitant about notifying a claim because there's obviously a concern about what impact that might have on the premium that you have to pay for your insurance cover. So look, that is something that has to be weighed up against the real risk of delaying notification. So in construction contracts, I'm sure that some of you have been involved in projects where, almost daily you have felt that there is a risk that you could end up with a claim at some point, because they're just the nature of it can be quite a contentious environment. And in those cases, that's pretty tricky to decide. I actually did have one dispute with an insurer for a construction client who had notified a claim, and there was an argument about whether they were too late in doing so. And the point that boiled down to looking at the minutes of site meetings, should it have been obvious that a claim was going to emerge down the line? And the point that we were making was, well, look, you can look at any site meeting minutes from any project across the land, and someone could say, well, these people aren't necessarily getting on particularly well, but you couldn't be notifying your insurers every day that you have a bit of a Barney in a site meeting. So there's a bit of a balance, but again, the broker is there to assist you and give you a bit of a steer as to whether it is something that should prompt a notification. So reasons for refusal to pay out. If you make a claim, then your insurer is going to analyse very carefully whether you have complied with your obligations. So Rebecca's been through those. Anecdotally, I would say that there has been a sort of hardening of the position of insurers over the last number of years. I kind of have flipped from one side to the other. So I spent a lot of my career advising insurers, and I'm now more likely to be challenging their decisions. And certainly there seems to have been a shift towards, maybe going a little bit far to say, but that almost every claim that is made, the default seems to be to look for a reason for it not to be paid out, which wasn't always the case. It's maybe just sort of part of the way that the whole world has gone. But yes, if there was a failure to disclose something at the inception of the policy, then what does that mean? Well, the question really is whether there was a fair presentation of the risk to the insurer at the time. So if the insurer was induced by your breach to enter into the policy on the terms that it did, then anything after the Insurance Act, if there was a deliberate or reckless breach, that policy will be void from inception, which means that there's the insurer can refuse all claims, and they can even keep the premium that you've paid. So before 2016, they at least had to give you back what you'd paid for the cover, but no, that's gone. But the burden is on the insurer to prove that any breach was deliberate or reckless. More frequently, you're talking about a sort of accidental breach, so something that's been overlooked rather than deliberately concealed. So in those circumstances, the remedy really depends on what the insurer would have done if they had known about the thing, if they had received a fair presentation of the risk. So if the insurer can persuade a court that they just wouldn't have insured you, then effectively they're allowed to avoid the policy. If they would have insured but on different terms, then what the court will do is sort of retrospectively apply those terms and deal with the scenario based on what would have been the terms. So it could just be that they would have insured you but for a higher premium, in which case the difference between what you paid and what you should have paid would just be deducted from the claim. Another common reason is failure to notify at all or in appropriate time frame. And like we talked about notification, policies do vary on this point. Some are pretty strict on notification, others are very loose around it. So just again, something to be aware of. Probably the most common reason that an insurer won't pay out is that they say, well, sure, your cover doesn't cover this scenario. Or they'll point to some exclusion or limitation within the policy that they say excludes cover in the circumstances. So the thing I suppose that adds to all of that uncertainty is that policy wordings aren't standard things. They develop and grow, sort of grow arms and legs, and across different insurers, and even within the same insurer, they will have all number of different slight different tweaks to their wording. And that means that there is a huge amount of case law which has always been generated on the interpretation of insurance policies, and that's constantly evolving. You could have a whole seminar on that, which we won't bore you with, but I suppose the basic principle when looking at a policy is what would a reasonable person with the background knowledge reasonably available to both the insurer and the insured have understood the parties to mean by the language they use. So, it's supposed to be the sort of objectively looking at it, what were they trying to cover? But like it's a huge source of debate and argument between insurers and policyholders. I mean, the clearest, most recent example of that was the business interruption saga post the COVID outbreak, where the Financial Conduct Authority actually issued a test case to try and get some clarity over whether policies responded to COVID. So that, you know, that was pretty high profile and it made the news. And but really that's a good example of how we can get into debate with the insurer. Exclusions, sort of similar issues apply, but the burden would be on the insurer to prove that a particular exclusion applies. So they would have to prove that was applicable in the circumstances. So if you do end up in dispute with your insurer, then how do we resolve that? So moving on to that, the first thing to look at, I suppose, with your broker is whether there is a prescribed dispute resolution mechanism within the policy. Quite often there might be provision for arbitration or some sort of early expert determination short of full-blown court litigation. So that's fairly common, arbitration in particular in commercial insurance policies, not so much for Joe Blogs. So that if that's what the policy says, then that's what happens. You can't sort of circumvent that. The other route, which is cheaper and potentially a little bit faster, is to make a complaint to the Ombudsman. Now, the Ombudsman is, again, mostly aimed at consumers, but does provide a mechanism for SMEs to challenge decisions of insurers. So, look, there are limits based on turnover and things, but if you fall within that, it can be an interesting option and it's something we can assist with. The third option, which is kind of our bread and butter, is where you don't get anywhere with the insurer in terms of trying to resolve things. So you have to issue proceedings, and in those circumstances, then we're back to basically what we do in terms of issuing pre-action correspondence, trying to resolve things before we issue. If that doesn't work, then you're issuing a writ. Usually the figures will be such that you'll be in the High Court, and the case will be in the commercial division of the High Court, and we'll just move through in the normal way. As part of litigation these days, alternative dispute resolution mechanisms are often tried. Mediation is probably the most common and most familiar to people now. And actually mediations involving insurers are very, very common. Mediation is a process that is sort of less costly and more effective, arguably, at resolving disputes than full-blown litigation, albeit that I would say that a lot of insurers are reluctant to mediate at a very early stage. So you tend to have to go through a lot of the steps of the litigation before an insurer will agree to mediate with you. So just moving on to a couple of case studies. First, again, business interruption insurance. Like the pandemic put this type of cover on the radar and on the national news. And as we mentioned earlier, there was some uncertainty as to whether policies would respond to the COVID pandemic. So the test case issued by the Financial Conduct Authority was sort of fast-tracked to the Supreme Court. I will not bore you with the 300-page judgment that was issued, but it was generally favourable to policyholders. But it didn't sort of, create cover where there was clearly nothing there to begin with. So it really just confirmed that if you had a policy which covered you for business interruption, which wasn't just linked to physical damage to your property. So a lot of business interruption policies only kick in where you can't, your building is burnt down, or you can't get into your building because of some physical damage to the building, or flood, say there's a flood or something of that nature. That wasn't enough. COVID didn't sort of cover you if that's what your policy said. You had to have a policy that had provision for business interruption cover where the interruption to your business was not purely as a result of damage to your physical damage to your property. But look, again, it brought out how varied the wording of these policies can be. I mean, for the purposes of that case, there were sort of about 40 different standard wordings selected, so that the court considered all of them. The hope that people could look at their policy and say, well, it's similar to that one, it's similar to that one, and they were considered whether they would respond or not. We've advised a number of clients from various sectors. You know, the notion that it was just sort of the hospitality industry who were impacted is not correct. We've advised a number of clients in the aftermath of that Supreme Court decision as to whether, you know, where they stood, whether that helped or hindered them and their claim. We were also recently involved in what would have been probably the most significant business interruption case in Northern Ireland in terms of value, because it was tens of millions of pounds. But it's settled, which is obviously good news for the client. You know, it'd be quite interesting to see it go through the courts. But in effect, that was essentially a contractual dispute. So there was clearly a cover. There was an interruption event which occurred, but post-COVID, the insurer had attempted to put some sort of limitation on the level of cover for business interruption, and there was a dispute as to whether that limitation had made its way into the new policy during the renewal process. So rather than, it was really just a contractual dispute, but in any event, it did. Clients had mediated with London lawyers before they came to us. We issued pre-action correspondence, and it was ultimately settled, you know, favourably. But yeah, good example of you know, the type of case law that insurance disputes can generate. Potentially, more sort of mundane case study relates to, again, fire damage. Rebecca used one of those examples previously. We had a client who had a pretty severe fire at their premises, and the material damage clause included a sort of condition precedent that there had to be an annual fire safety check, which was to cover 100% of all the appliances and things of that nature that could cause a fire risk. So the client had instructed a fire safety expert who had carried out, rather than one annual check, three checks every year, and in each check, a third of the appliances were checked. So believe it or not, the insurer rejected the claim initially on the basis that the most recent fire safety certificate only covered a third of the appliances. And of course, the client very, very quickly through a broker had said, well, sorry, if you look, here are three which cover the whole year, but no, there was a sort of, the shutters came down and the insurer refused to pay it out. So that particular client fell within the financial turnover limits for recourse to the Ombudsman. So having written an initial letter which didn't get anywhere with the insurer, they were just ignoring things, probably hoping that we would all go away. We complained to the Financial Ombudsman Service, and we went through that process, which I think, but for we were still dealing with sort of the backlog following the pandemic. I think, but for that, it would have been really quite swift. But the outcome was that we got a favourable decision from the Ombudsman. So that meant that we could, now that should have been the end of it, and 99% of insurers would have just paid out at that point, but no, this insurer continued to ignore us. So we did have to issue proceedings, but those proceedings were much simpler than they would have been if we didn't have the Ombudsman's decision. So we didn't have to prove anything about the policy. All we had to do was sort of say, here's the decision, this should be enforced. And when we did that, the insurer paid out. So again, like that was an example of the FOSS procedure working really well for a client. It won't apply to all of you. Some of you will be too big, unfortunately, to use that, but it's worth checking. So look, that's been a real rattle through what is a fairly complicated area. Key takeaway points from my point of view, really, first of all, use your broker effectively. They're there to get things right from the beginning, to make sure that your cover's in place that you need, but they also will sort of guide you through any claims process. So that's a really key relationship. Know your obligations. Rebecca's explained what is required of you high level, and I've explained what can happen if you haven't complied with those. It can be fairly catastrophic. So know what's required of you, both at placement and renewal. Renewals, it's, you know, a lot of people's minds are really focused when you're first obtaining the cover, and things can slip through the net at renewal because you have an ongoing obligation to bring things. So if something dramatically changes in your risk profile, you know, you have to tell the insurer that that's happened, so that they can decide whether they're going to increase your premium or whether they can cover you for the new thing that you're doing or whatever it is that's changed. Comply with notification requirements, know what they are. Again, that just eliminates any risk of the insurer, you know, taking issue with that. Keep good records, both, you know, just generally, always helpful in litigation where the client has a good record of things. If you have an event which is going to give rise to a claim, if you keep good records of the losses that you sustain, then it just makes things easier when it comes to quantifying your claim. And look, as we always say as lawyers, you know, take advice early. If you find yourself in dispute with your insurer, then, you know, come and speak to us and we will have a look, and we'll see what we can do to help you out. So listen, thanks for listening. There is an opportunity now to ask questions, although there's a real lawyer caveat that, as I've said so many times, every policy is really different. So quite often it's very difficult to answer general questions on, you know, does my policy respond in such and such a situation without looking at the policy. But if anyone has a question of that nature that they want us to take a look at their own policy wording, then our email addresses are up on screen at the moment. So you want to take a note of that, then you can fire one of us an email and we will come back to you. Otherwise, that's great. Thanks, everyone. Vincent.
Thank you. Thanks, Kirsten. Thanks, Rebecca. That was great. If anyone does have a question, please do use the Q&A function. There was one that might have been covered there in the last slide, but what would be one or two key pieces of advice that would help prevent an insurance company from not paying out on a claim?
Yeah.
I think you kind of did a whistle stop tour of the last slide, a couple of those.
Yes, but that kind of is it. It's as opposed to having in mind right from the inception of the policy through renewal to make sure that you are being as fulsome as possible in terms of your responses to the various questions. If anything gives you pause for thought, then, you know, there's probably a risk that if you don't tell the insurer that could come back to bite you. It's in a sort of colloquial way. So if you think, oh, they mightn't like that, it might be something that it's better to have out in the open and addressed at the outset, rather than that being something that is used against you down the line. And yes, look, the keeping your records, keeping across just, you know, the key terms of the policy, in terms of what your obligations are. But look, no matter how organised and how professional you are and how open you are with the insurer and your broker, that is never going to 100% rule out the risk that an insurer will find some reason, particularly in terms of the construction of the wording of each policy. So, and look, that it can be tempting to just say, oh, this is all too difficult. Don't just do that. You know, come and speak to someone, and look, we will quickly tell you if something's hopeless. You know, we're not in the business of getting into hopeless fights with insurance companies, but if there is, you know, it's just I suppose the point is, don't just immediately accept, oh, this has been refused, we mustn't have cover. You know, it's definitely worth probing that, particularly if you're talking about a significant claim.
Okay, super. Thank you. Thanks both. That was great.
Not a problem.
Thank you to Mill Selig now for the guidance on this. Thank you. All the best.
Guys, bye.